Welcome to our continuing 2018 educational webinar series. I am Catherine Short, Partnership Marketing Specialist for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Grant Elliott, President and CEO of Ostendio, a cybersecurity and information management SaaS platform. He is the former COO and CISO of Voxiva, now WellPass, an integrated messaging and patient engagement platform. He has over 10 years' experience developing and managing cybersecurity programs and supporting regulatory audits. Before working at Voxiva, Grant held senior positions at AT&T. Grant is also the co-founder and president of the Healthcare Cloud Coalition, HC3, a healthcare compliance advocacy group funded by, amongst others, Microsoft and Apple. He mentors at Accelerate DC Venture Mentoring Service and is an adjunct professor at the Pratt Institute, New York. A copy of the slide deck is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your Paycom CEU certificate will be emailed to you from Paycom following the broadcast. There is no need to request it. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. Grant, go ahead.
Thanks very much, Catherine. It's a great introduction, and I'm delighted to be here to discuss what's really an engaging topic, GDPR. As many of you will know, on May 25th this year, the General Data Protection Regulation, GDPR, is coming into force, impacting how businesses collect and process data from individuals. If you have or plan to have a website or any form of app that visitors may from the UK, the EU may visit, or you process any form or data from individuals from the EU, then you need to comply with GDPR. Good news is that if you're already operating in line with a regulation like HIPAA, then you may be closer than you think to being compliant with the GDPR. Today, I'm going to discuss a little bit about how you can leverage your HIPAA compliance activities to make GDPR less of a lift. Let's begin. So the agenda today, we're going to cover an overview of the GDPR, some of the key changes and how it impacts you, how it applies to US companies specifically, and steps you can take to prepare for the arrival of GDPR. One just general caveat here, and just to be clear, I'm not a lawyer, and so any information we provide during this presentation is not considered or does not constitute legal advice. If you're looking for specific legal guidance with regards to GDPR, please consult your organization's lawyer or seek independent legal counsel. So let's move forward. Okay, so basically, what is GDPR? So the EU General Data Protection Regulation, GDPR, is the most important change in data privacy regulation in 20 years. It includes especially onerous requirements with respect to data subject rights, and third-party compliance. The EU GDPR replaces the previous Data Protection Directive 95/46 EC. It was designed to harmonise data privacy laws across Europe to protect and empower all of EU citizens' data privacy and to reshape the way organisations across the region approach data privacy generally. As we say in the slide here, there is no one-size-fits-all approach to this. If we actually look at some of the key definitions, first of all, GDPR predominantly applies to two different entities, and these entities are called controllers and processors. A controller is a natural or a legal person, a public authority, agency, or other body which determines the purpose and means of processing of the personal data. They're basically the people that manage the data and kind of, for lack of a better term, own the data. The processor is responsible for processing personal data on behalf of the controllers. They're typically doing something on behalf of the controller. So who does GDPR apply to? Okay, so basically it's any company located in the EU, because effectively they have EU citizens working for them, but also any company monitoring the behavior of EU citizens. As you can see, GDPR has a much wider breadth of the data that governs than typical data regulations or security regulations. HIPAA, by comparison, has a much smaller realm and is limited specifically to PHI, or protected health information. To comply with GDPR and avoid fines and penalties, companies must have a thorough and current understanding of all of their data assets. So let's have a look at some of the key changes that are basically coming up. So we're going to discuss each of these in more detail as we go through the presentation, but the key elements to think about are breach notification, right to access, data protection officer, or DPO, right to be forgotten, data portability, data security by design and by default. So again, as GDPR comes in, what are the fundamental differences between GDPR and a regulation like HIPAA? Specifically, as we mentioned, HIPAA is limited to the protection of personal health information, PHI, whereas GDPR is focused on fundamental consumer protection rights. One of the centerpieces of GDPR is the strengthening of individual rights. So the key concept really there is that HIPAA is very specifically focused on the type of data that's being managed. GDPR is very much focused on the individual the data belongs to. So again, let's look at this in a little bit more detail. GDPR puts forth clear guidelines for when health can be processed, or essentially when it can actually be assessed. Again, GDPR specifically says that you have to have the explicit consent from the individual. For health, it has to be for the purpose of health and social care, or it has to be for the purpose of public health. So, for example, cross-border containment. HIPAA has similar definitions, but again, it's slightly different. It's specifically for the treatment of the patient, payment of any healthcare related activity, or any general healthcare operations. You can see actually it's a much narrower definition of when the actual data applies. So how do we leverage the difference between these two? So Article 32 of the regulation mandates that controllers and processors implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. GDPR's data concerning health is comparable to regulatory requirements for HIPAA. Like I've already said, you have to have technical safeguards in place for both. A couple of other points related to this. Adherence to an approved code of conduct is referred in Article 40, or an improved certification mechanism as referred to in Article 42 may be used as an element by which to demonstrate compliance with the requirements set out in paragraph 1 of this article. What that's basically saying is that GDPR itself is not its own security or privacy framework, but if you're aligned to another security framework on an equivalent industry accepted practice, then you can use that practice or that framework basically as your guiding principle for being compliant to something like GDPR. Now again, each of those frameworks has its own pros and cons, and HIPAA itself is a regulation rather than a standard, but there are certain elements of the HIPAA regulation that, because if you're already compliant or operating in line with, then that's going to stand you in good stead with any other recognized security framework. So what are the big differences between GDPR and HIPAA? Probably the biggest one is when it comes to data breach. People may be familiar that in 2013, the final omnibus rule for HIPAA came out and really redefined the breach notification requirements for HIPAA. The time period remained the same, which was 60 days from the discovery of a breach, but the responsibility between a covered entity and a business associate was basically made equal. So again, now business associates had to report within the same time frame, regardless of what their business associate agreement says. GDPR is far more strict, and GDPR actually requires 72 hours to actually report the data breach from the point of discovery. Now, for many people, that might not seem such a big jump because, again, if you review many business associate agreements, you'll see that many covered entities actually require or suggest or put in the contract that their business associates do respond in much shorter timeframes. Although typically what we normally see is that's closer to 10 days than 3 days, but I certainly have seen them requirements for 24 hours, 72 hours. The big difference here is, again, if your covered entity is asking you to provide a report within that time frame, your responsibility is a commercial responsibility to that entity. This 72-hour GDPR requirement is obviously a regulatory obligation under the law, and so if you fail to meet that particular definition, then it's not just your customer that's going to be coming after you; it potentially is going to be the EU. So let's move on to some of the other areas within GDPR. There's right to be forgotten. So also known as data erasure, the right to be forgotten entitles the data subject to have the data controller erase his or her personal data, cease further dissemination of the data, and potentially have third parties halt processing the data. The conditions for erasure include the data no longer being relevant to original purposes of processing or data subjects withdrawing consent. There has been some really interesting court precedent cases even prior to GDPR coming in, with people actually arguing for their information to actually be removed from various different third-party organizations. And this is going to be one of the hardest ones, I think, for organizations to police, because again, the question comes into, if an organization has it, say for example, Google is the organization and it's part of a Google search, what are the requirements in terms of removing that information? Is that information public record? Clearly, when it comes to more of a private organization, if you're doing business with a particular organization, then there's maybe a little bit less controversy over the right to actually have the data removed. But fundamental to being able to have the data removed means that the organization itself needs to understand what data they have and where that data actually is. And so you cannot guarantee that you're removing someone's data from your system if you don't know everywhere it is. Good examples of that might be, maybe you remove their data from your production systems, but you have back-end development systems, or you have staging environments, or you basically have internal CRM systems. You have to understand that that person's data is in all of those environments. And if someone makes the request for that information to be removed, you need to be able to make sure and confirm that you've removed it from all those different systems, not just the production systems. And again, if you're working with a cloud provider or you're working with some sort of third-party organization, you also have to ensure that they're removing that data as well if you're going to comply with the request. And that can obviously be difficult, especially if you're working with cloud providers like Amazon Web Services or Microsoft Azure, because they don't necessarily always identify or know what data belongs to a specific individual. They're managing the data in aggregate, and so you have to have tools or capabilities to be able to actually go in and make sure that they're actually removing that information and not just overwriting. If we move to right of access or right to access, again, this is very similar to HIPAA, where people have a right to access their information. Again, an individual has the following rights: to obtain confirmation whether his or her personal data is being processed, to access the data and be given a copy of that data, and to be provided with supplemental information about the processing. Again, people under HIPAA have the same rights with regard to the healthcare data. But the big difference here is that under HIPAA, you only have the rights to information that falls under the jurisdiction of HIPAA. So as we talked about earlier on, information for the treatment and management of your care, any other information doesn't fall under the right to access from a HIPAA perspective. But when we talk about GDPR, we're talking about any personal data at all. So again, if you go to your local CVS, if you go to anywhere, if this information falls because you're an EU citizen or someone is an EU citizen, any data you provide that's personally identifiable, basically you have the right to get a copy of that record from any organization. Again, I want to put the same concerns that we had on the right to be forgotten. That basically means that you need to be able to understand what information you have, the complete information that you have, and be in a position to have a process where you can demonstrate that if someone makes that request, you can follow that request up and you can deal with it. And you need to also be able to report on the fact that you're monitoring and tracking those types of requests, and you have a process in place for how you're actually supposed to be dealing with those specific requests. Let's move on to data portability. So GDPR introduces data portability, the right for data, for a data subject to receive the personal data concerning them, which they've previously provided in this is a definition, commonly used in machine-readable format, and have the right to transmit that data to another controller. And again, this is very similar to some of the requirements under HIPAA, because again, if you go from one doctor to another doctor, or one provider to another provider, you theoretically have the right to require them to transfer your patient record to the other physician or the other. Now, anyone who's used the US healthcare system knows that's probably not as easy as it should be, and practically can pose challenges. But you absolutely have the right under HIPAA to basically have your information moved between different facilities. GDPR follows the same process. Obviously, again, it's going to be interesting to see how organizations meet this particular requirement because of the data compatibility issues. But again, the idea really is that, again, for specific use cases, this is going to be easier than others. There are systems and industries where there is immediate compatibility, and that information should be able to be moved. But there's obviously going to be other situations where organizations are going to have to come up with mechanisms to make sure that they can both send and receive that types of data to other controllers. Moving forward again, we've also introduced this new concept of a data protection officer. So again, one of the interesting differentiations between HIPAA and a lot of security frameworks is that HIPAA actually requires that there is a dedicated security officer. The HIPAA doesn't actually mandate a privacy officer. It does recommend a privacy officer, but a data protection officer would be similar to the definition of a privacy officer under HIPAA. And again, so each organization has to define a data protection officer. Now, the data protection officer doesn't have to be dedicated. It doesn't have to be their only job, but you have to basically be able to define within the organization a person who fundamentally is responsible for data protection within the organization. That person, as you can see here, has specific requirements. They need to report to senior management, although the definition of senior management can obviously be variable. They need to have the ability to operate independently from the rest of the company. They also have to have adequate resources to perform their role. Obviously, as we move into this and we start having more audits, more investigations, some of those terms are very vague, and so it's going to be difficult in the short term to determine whether or not, is the person reporting at a senior enough level? Do they have sufficient independence, given that they're a company employee? And what is adequate resources? Because again, the way that HIPAA works quite often is, HIPAA itself does not always define what adequacy actually is until actually the OCR themselves are actually investigating some sort of breach, and they'll make a determination. And so often, if you are making a determination based on the end result, i.e. there's been a breach, then quite often the answer coming back is going to be that you had insufficient resources, insufficient practices in place. So it's going to be interesting to see as we move forward with GDPR how they basically define, or as precedent determines, what adequate resources is necessarily going to be. And again, DPOs can either be an internal or an external role. They simply just have to be defined. So it may well be that you can actually outsource to a third-party consultancy group, contractor organization, security, law firm, etc. As long as they have the appropriate influence within the organization, then that's all that matters. Okay, so a key thing that as we move forward within the GDPR is this concept of data security by design and default. And really what they're saying here is that you cannot just add security in as an overlay. You can't build your processes and design your product and your services and then think, okay, what are we actually going to do then from a security perspective? They're really asking you to basically demonstrate that as part of your product development process, part of your software development process, part of your operational build-out process, that you can demonstrate that you're actually building security in through the design and the product development process. So it's fundamentally asking you to be able to demonstrate and prove that. And so with regards to that, there requires controls and processes to conduct data protection impact assessments, similar to what we're used to as being a risk assessment within the HIPAA world, or within the general security world overall. And that assessment basically has to happen across the entire organization. We become very familiar with the concept that many people think that data security and privacy is very much an IT-centric process, but the reality actually is that, particularly when it comes to privacy over security, but security as well, we're really looking at the life cycle of where data is flowing as it comes into the company, where it flows through the company, and who has access to that information. As you can conduct these types of assessments, it's important to actually conduct assessment in all parts of the organization that theoretically can touch the data. And again, that's kind of one of the requirements when they're actually designing this process. As the data comes in, as the data goes out, you need to make sure you're capturing and tracking mechanisms to ensure that the security is built in and privacy is built in by design. So let's look at evaluating security measures. Again, similar to HIPAA, this is a continual process. The idea is not just that you conduct and you start off doing a basic risk assessment to understand what your capabilities are right at the beginning of the process, but this should be a continual, ongoing process. More often than annual, but certainly from a weekly, from a monthly basis. If you've built this in from a design perspective, then there's going to be lots of individual components of a security and privacy program that you're going to be routinely managing from an ongoing perspective. Examples are going to include things like penetration testing, intrusion detection, building in business continuity plans, building in redundancy, basic encryption across the environment. And again, all of this is going to be underpinned by these ongoing assessments or the data protection impact assessments as defined by the GDPR. And so there's lots of different ways to make sure that you're implementing. And going back to the point I mentioned, again, you can certainly look at HIPAA and as defining some of the key elements of this, but really most of the people that are going through HIPAA are typically going to use a more industry robust security framework, maybe a SOC 2, maybe ISO 27001, NIST 800, 171 or 53 in the US. There are lots of different security frameworks, and all of these security frameworks, again, maintain and define very specific standards and lots of different control areas for how you go about operating an effective security and privacy program. And obviously, we've listed a few examples here as well. So, what happens if you don't do this effectively? What is the downside? Well, one of the criticisms I think today of HIPAA, even although we continually see from time to time in the news a major breach and a major fine for a non-compliance, really in the great scheme of things, given how many organisations there are that covered under HIPAA, the amount of fines against that are not considered to be particularly high. And typically, if it is a $2 or $3, $4 million fine, which again are rare, but when that happens, it's typically a much larger organisation that fine's been applied to. So how much of a punitive effect that really is. If I think there's one thing that's really getting people to sit up and take notice for GDPR, it really is the fine component. So again, 4% of annual global turnover, or 20 million euros, whichever is the greater. But that again can be per breach type. So again, there can be potentially greater fines than that, because again, as I said, it's a tiered approach. And so it really is quite a financial incentive for organizations to make sure that they are actually operating in this space. Now, it's going to be interesting to see when the first of these fines or non-compliance is actually determined. As we talked about earlier on, the framework comes into effect on May 25th. Clearly, there's going to be a time period by when people will theoretically be breaching it or not following it. There has to be some sort of a discovery process where, again, someone discovers that an organization is non-compliance. There typically tends to be a notification period when someone's notified as being non-compliant, and potentially an opportunity for that organization to either remediate the non-compliance or to protest or disagree with the initial assessment. And then at some point, there's going to be ultimately an adjudication and a fine, and potentially even an appeals process. So in terms of what we're going to see in the media, in terms of what we're going to see publicly, it could be a long time, a month, maybe even years, before we actually start to see significant action being publicized against GDPR. The important thing I think for people to bear in mind is just because you don't see it doesn't mean to say it's not happening. Again, typically breaches when they occur can be 18 months to 2 years before they're discovered. Again, if someone does report an action, it can be quicker than that. But if we don't immediately see on May 26th, companies suddenly being penalised for GDPR non-compliance, that does not mean to say that as an organisation, this is not something you should be spending time to make sure that you're operating in a compliant manner. It is going to take time for this to filter through the process, but you do not want to be the organisation that in 2 years' time is basically getting the 20 million euro fine or something equivalent because you didn't take appropriate action sooner rather than later. And again, based on surveys that have been conducted, we know that many organizations are not ready for this yet. 61% of organizations have yet to estimate how many requests for erasure they're likely to receive. If we actually have a look at the number of organizations that have indicated they're ready, obviously it varies by scale and size. And definitely from the companies I speak to in the US, there's starting to be an awareness of GDPR, but certainly not an education about what GDPR is and how it's impacting organizations. And so, thank you for listening to this webinar, because hopefully this will help you become a little bit more aware of kind of what your obligations and responsibilities are. Okay, so let's think a little bit more about what can you do as an organization. Again, if you're already operating in compliance with most HIPAA regulations, then as we talked about earlier on, you're probably doing many of the things that you need to be doing in order to basically demonstrate that you're operating against GDPR. HIPAA, again, is a pretty ambiguous regulation. So again, but if you've gone through an effective HIPAA audit, or if you're operating aligned with HIPAA and using something like ISO 27001 or AICPA SOC 2, again, you're probably a significant in the way there from a security perspective, from a privacy perspective, where most organizations are going to struggle, as I mentioned, is on this ability to understand what data you have and where it is. So really, it's really important that you really start thinking whether this is about HIPAA or GDPR, that you really understand what type of data are you holding. Be asking yourself the question, do you need the data? Do you need to maintain the data? Is the data essential for your business processes? But fundamentally, what type of data you have. The location of that data is critical, and as I mentioned earlier on, it's not just about your production facility, it's about where else within your organization does that data exist. Do you have people within your organization downloading customer data onto their laptop? Do you have development organization where you have a development environment or a staging environment? Do you have CRM systems where, again, customer data? Because again, unlike HIPAA, we're not just talking about the healthcare related data here. We're talking about any personalized data for that particular individual. And so again, it's really, really important you understand all the different systems you have within the organization, and you can basically identify which of those systems are going to maintain personalized data. Again, who's in charge of handling that data? So, if you have an organization of 10 people, 100 people, 1,000 people, 10,000 people, which people within your organization has a need to have access to this data? You're going to have different people in the front line who are going to be handling this data as kind of part of their overall business responsibility, and we can call that direct access. You're going to have people that we have incidental access, that is not their core responsibility to handle that data, but they will potentially come across it from time to time, maybe because they're handling tickets, and every now and then a ticket has that information whether customers should put it in or not. So again, people will come across incidental access, and you need to have a plan for that. And then we have what we call theoretical access as well. And theoretical access is really, you don't have day-to-day access, you're unlikely to have incidental access, but you're in a position of responsibility that organizationally you could request to have that access as well. Again, people need to understand that they're not supposed to do that. So again, maybe you're the director of the software development team, so theoretically you could ask to see information. Maybe you're the CEO or a president of the organization. You have the authority to ask for access to the information, so you have to be making sure that you've got processes in place to provide and protect against that type of access. And then, as we mentioned, how much data do you really need to retain, right? Again, and how long do you need to retain it for? Do you have good archiving policies? When you archive data, are you basically marking for delete, or are you actually deleting and physically removing the data? Most computer systems today, when you delete something, doesn't actually delete it. It simply just makes the record free, and then it's overwritten at some point in the future. And so it's important you understand those kind of technical differences, because again, if someone's asking you to remove that information, then you have a responsibility to do so. And then more importantly, once you've basically implemented many of those processes, you need to make sure that you're conducting routine and frequent audits to ensure that, again, everyone who is theoretically or incidentally having access to this data understands their roles or responsibilities. You're validating who should have access, you're validating where data is, and you've got cross checks in place to make sure your processes and procedures are being followed. So what else can you do? Again, as we start preparing for this deadline coming up, or as the deadline has passed, again, we talked about conduct a data protection impact assessment or a risk assessment. If you've not done one of those today, not only will you be in violation of the GDPR, you're already in violation of HIPAA if HIPAA applies to you. Every organization should have conducted some form of risk assessment. Security and privacy is a risk-based process, and so you need to understand what kind of risk you have from an organization. Typically pick an industry recognized security framework. I've mentioned a few already. Again, ISO 27001, NIST 800-171 if you're in the US. Again, ISO 27001, AICPA SOC 2. If you're, again, healthcare related, high trust, again, is another framework. There are lots of different frameworks available that are accepted generally across various different industries. And so it's important that you've implemented one. A single framework may or may not be sufficient for you to meet the requirements of GDPR, and especially when it comes to the privacy components, there may still be additional things that you have to do. But again, if you're operating against one of these frameworks, you're going to be a significant of the way down, and again, you're going to point to that as your framework, as your attestation as to why you believe you're operating in alignment with the GDPR. Make sure you're doing, again, as we talked about, effective incident response. Again, security and privacy are incredibly important, but not just from the theoretical breach access, but it's also about availability and integrity of the data as well. They're just as critical. So making sure you've got effective incident response, so you understand who theoretically has accessed it, you understand how you can actually respond to those incidents, you have an effective business continuity plan, that you understand how you can basically do disaster recovery. Again, you want to make sure that this information is accessible and available, and you know where it is, and that people can basically access it any time. So you have to have effective plans in place to do this. And then, Gartner did a study recently that basically said that something like 60%, only 60% of applications and services within an organization are basically managed by the IT organization. Up to 40% are what we call shadow IT. So this can be cloud-based services that the marketing team signs into, or another division or department signs into. Make sure you understand that you have a process in place that makes it easy for you to track and manage that. Again, the more you lock down your organization, the more incentive you're giving certain people to basically fall outside the system. So it's important you understand all the assets you have. Are people using their own mobile device? Are people using home laptops? Do they have thumb drives? What other assets outside of your collection could data theoretically be downloaded to? And then make sure you're training your staff. Again, make sure every one of your staff understand what GDPR is, understand the implications of GDPR, but effectively provide good security training, and try and do this continually and an ongoing. Annual security training has been proven to not be effective. It might meet specific compliance obligations, but it's not really an effective way. And really the best way to be compliant with GDPR is to make sure you're operating in an appropriate manner. And again, training people is going to be the best way to do this. And lastly, document everything. If you don't document it, it didn't happen. If you don't have a policy or procedure to say you're following a particular path, then again, you can't guarantee or demonstrate you're following that path. If you're not tracking and managing who has access to information or data, then again, you can't demonstrate you're having control of it. So effective documentation, effective policies, procedures, standard operating practices. Again, make sure that you have a really good and robust documentation history, change management history, document and track it as best you can on an ongoing basis, because that's going to be your best defense. And when you actually conduct your risk assessments, you're going to be conducting the risk against the information that you're tracking and managing. Okay, so again, just a reminder and just more as a sum up, questions that you're going to need to be able to answer from an organizational perspective is, what type of data do we have, right? Where is that data being held? Who is actually in charge and managing that data, or potentially who even has access to it? What is the data being used for? Again, that's going to essentially come down to who needs to have access to it. Is the data still relevant, and is retention even necessary? Again, depending on the different acts, in today's environment, we have a tendency not to want to get rid of data because we think that analytics and the history and the understanding the patterns of that data is important. But again, legal advice typically says that the more data you retain and the longer you retain it, then the more risk that you're simply just maintaining. So you really ask yourself the question whether you still need that information that's 2, 3, 4, or 5 years old. And again, there might be regulations that require you to keep it, but again, that you should be doing it for a progressive purpose. And then, what security measures are in place to protect the data, as we've talked about earlier on, make sure you're operating against an effective security framework. And then, can the data be accessed and furnished to make the individual concerned should they make a system access request? And that goes to the point I mentioned earlier on in the webinar, which is, do you have a process in place for when someone asks for access to their information? Are you able to facilitate that process? Would you even know that request? Is there a mechanism in place where individuals understand where to make that request, and you make that easy for them? Do you have a process for managing it? How will you get that information to them? Can you provide them that information in a readable format as per required by the regulation? So in conclusion, it's really important to understand that GDPR is much more aggressive than HIPAA, particularly when it comes to privacy. And that's, again, a key differentiator. So again, while operating in line with HIPAA will take significant steps towards operating in line with GDPR, do not think that just because you've gone through a HIPAA audit and you've passed that, or that you think you're operating with most of the requirements of HIPAA, that's in itself going to make you compliant to GDPR. As we talked about earlier on, the information set's different. HIPAA is related to the specific information related to the care and treatment of healthcare, whereas GDPR is specifically related to the personal data of an individual. So again, there's a big difference in the type of data. If you've already got technical safeguards in place, then that's a great start, right? It's important to understand that what you've got in place, build on that, because again, none of what you've done to put in place in order to operate in line with HIPAA is going to be wasted. It's just a question of building on top of it as well. And as I mentioned earlier on, just because we're not going to hear anything in the press or the media about enforcement taking place for a few months or years, does not mean to say that it's not happening. It does not mean to say that companies are not being notified in private. It does not mean to say that things are not happening behind the scenes, because again, the moment that the fine is announced in the press is going to be somewhere down the line. But again, the actual non-compliance will have happened much sooner than that as well. And really, I think the key thing is, from an organization, be as transparent as possible. Try and make sure that you as an organization, you're communicating with your staff, communicating with your customers about what your processes are in order to try and operate in alignment with GDPR. And then again, all organizations posting health data will need to review their existing policies and practices to ensure compliance. Again, most organizations have something in place. Again, if it's aligned with HIPAA, that's great. If it's aligned with another framework or another standard, that's good too. But again, you need to review everything in line and map it specifically to the specific articles of GDPR, so that again, most of the different security and privacy controls within GDPR, although they're very general, are kind of mapped out, and you should be able to map and align them to specific. If you're already operating ISO 27001 or NIST 800-171, you can map the specific articles to the specific controls and domains within each of those frameworks, so that when someone comes in and asks you to demonstrate that you are operating in line with GDPR, you can make it simple enough. You can simply align the different components to whatever framework you're operating. So just, what do we do, and just a little bit about why we are obviously interested in GDPR. Basically, Ostendio's MyVCM is a SaaS-based information management platform that allows any organization to manage their entire cybersecurity and privacy program. We allow you to build out the various different workflows for your security and privacy program, and map and track it to multiple standards and regulations, So again, if you are already operating our platform in alignment with SOC 2 or ISO 27001 or NIST 800 171 or all three of those, it becomes really easy for you to basically align those specific activities with the specific GDPR requirements. And so again, what we do is basically three things. We help you build a pathway to manage the security compliance of whatever standard or regulation you're looking to operate against. The platform as a workflow tool actually operates that activity for you. So it's distributing policies and procedures for electronic signature. It's managing your training program. It's managing and tracking your assets and your vendors and all the different places where we talked about storing and accessing and understanding where your data is. And then it gives you that ability to easily demonstrate that you're operating in alignment with those specific standards and frameworks. So with that, I'm going to pass it over to Catherine to see if there's any questions from the audience.
Hey, thank you so much, Grant. Appreciate that. It's a very, very interesting perspective, and we definitely have not had anyone talk about this. So I really appreciate you presenting this webinar today. So we did have a few questions. So does GDPR only apply to electronic data?
So not specifically. Again, obviously, most data today, if you look at how much data we have in the world today, most data today is electronic. And electronic data gives us a whole interesting concept of data ownership, because if it's electronic, it can be duplicated. Who really owns data? But actually, GDPR really applies to any data belonging to the individual. And so, again, if you've got people faxing information in, if you get people basically filling out paper application forms, etc., any data that anyone has basically falls under the concept of GDPR. That said, I think it's important people generally understand that maintaining paper records often is a lot easier to secure than electronic records. So really, most of the application of GDPR really does apply on an electronic basis, but the regulation itself isn't specific to electronic data. Applies to all data.
Okay, yeah, I think everything pretty much turns into, even if it's not electronic originally, it turns into electronic eventually, right?
I've been to some providers, even today, some providers in the US that still are struggling to get everything.
True. That is true. All right, so we had another question here. Does all personal data need to be encrypted when it's stored under GDPR?
So again, this goes to the concept of GDPR not being that prescriptive, and the concept that really what GDPR is trying to encourage you to do is make sure you're operating in line with an effective security program. So it's interesting. A lot of people think that HIPAA requires information to be encrypted, but actually the requirements within HIPAA for data encryption are considered to be an addressable requirement. Now, that said, when many of these regulations were written, so back in 1996, encrypting data was seen to be quite challenging, but kind of hard and expensive, depending on the way that you did it. Really, today, there really should be no need, there should be no excuse for not encrypting data at any particular point in time. And so the way that HIPAA specifies this is that it says that you should, if you're not going to encrypt it, you need to just implement appropriate equivalent controls. But fundamentally, you still have to protect the data. I think you'd struggle to get through any form of risk assessment today where you could come up with a justifiable reason for why you're not encrypting the data. As you conduct a risk assessment and you're understanding the risk of the data you're managing and tracking, to try and identify that data is at the point where it's not worth encrypting would be a hard justification. And an example of that, I think, today is even just general websites today. I mean, Google have come out now, and Google really give you a low ranking score if you're not encrypting your website from a transport perspective. So if your website's running HTTP rather than HTTPS, you can get a lower Google ranking score, and that really is more a reflection of just how easy it is today to encrypt the data you have. So yeah, so it says GDPR doesn't specifically say that you have to encrypt your data, but I think you'd have to go a long way to justify that whatever security framework you're operating to suggest that why you wouldn't encrypt that data. There are unique use cases. I've got a friend of mine that works and the aviation industry, and they use things like X25 technology, which again is very legacy infrastructure. There are obviously issues with mobile devices. Again, text messaging, etc., has limited encryption. There are specific use cases where there may be justification for minimal or no encryption, depending on the data being sent. But again, really that's coming down to whatever risk assessment you conduct, the data you're managing. Your security framework will determine whether you're implementing appropriate controls or not. And given how easy it really is to encrypt data today, again, I think you go a long way to come up with a justification for why you would encrypt. So I think under that perspective, you could make the argument that because GDPR is requiring you to apply and comply with reasonable industry standards, then the inference should be that you should be encrypting your data, but it's not that specific in terms of the regulation itself.
Okay, great. And we had another question. Is there a GDPR certification?
Again, similar to what I said before, not specifically. Again, GDPR at the moment really requires organizations to operate in line with an industry acceptable standard. The EU themselves, and I'm trying to remember what article it is, specifically stipulates that they will approve, and they have a board that will basically look at and approve specific frameworks and certifications. But as far as I'm aware, there's no plans to come out with a GDPR specific certification or EU controlled. They're really looking for you to again, operate in line with the regulations as they determined them. And the big part from a security perspective is to make sure you're operating in line with the kind of industry accepted standard. Now, when they're going to publish what those standards actually are, and given that, for example, HIPAA is not a standard, it's a regulation. There's obviously some ambiguity there. If you basically said you were HIPAA compliant, how would you be determined what HIPAA compliant actually is, given that it's a regulation rather than a standard? But certainly, I think if you're operating against like ISO 27001, NIST 853 or 171, if you're operating against a well-established industry security framework, then that's really kind of going to be how you're going to be able to demonstrate GDPR compliance, rather than like some GDPR specific standard that the EU have developed.
Okay, great. So attendees, if you have other questions, I think we're just about out of time. So we'll answer any other questions directly offline, but please send those to us. Grant, did you have a contact page there on your slides?
Yes, I do. There you go. Thank you for the prompt. There you go.
Okay, great. So, so attendees, please use the contact information on the screen for any questions. You can also send us questions, and we will forward those on to Grant. And did you have any other final words for us, or advice, or?
Yeah, I think the last thing I'd probably say is that I wouldn't necessarily be intimidated by GDPR per se, because I think that I say the same thing about companies that come to us and talk about HIPAA, which is HIPAA is a means to an end, and GDPR in many ways is a means to an end, in the sense that as an organization, as a company, we have a responsibility to operate and secure the data that we're entrusted to provide, and we should be doing that anyway. And so, responsible organizations who are looking to operate an effective business and are looking to be responsive to their customers and their clients should already be doing most of what GDPR is requiring us to do. Now, the slight nuance to that is the ability or the need to track individual data and an individual data record, which is a slight uplift in what most organizations need to do. But for the most part, most of implementing GDPR compliance is really implementing common sense information security programs. And 90% of it is there. There are a few other things, as we've talked about, that go above and beyond that. But I think most people should feel comfortable that if you're operating and you put 90% of that in, then that's going to be a good start for you. And then just work on being aware of those other elements above and beyond. But again, this should be, for organizations that are already operating responsibly, this should not be as big a lift as maybe they might worry that it is.
Okay, great. Thank you. Thank you so much. And thank you for bringing us this webinar today. We really appreciate it. Thank you so much.
You're welcome. I've enjoyed it. Thank you.
Thank you. And thank you, attendees, for coming and joining us. And you can register for any future webinars or request a demo of our compliance solution on our website, which is firsthcc.com. You can call us also at 888-543-4778. And thank you for joining us.